all of you to the live virtual classes of Board of Studies, ICAI. We are into CA intermediate course and dealing with paper on corporate and other laws. And today's topic for discussion is interpretation of statutes. As you would notice, interpretation of statutes is a general topic and is an important topic from a perspective of analyzing and looking at different laws. So, as lawyers, there are certain rules which you utilize for interpreting or understanding the laws, and the courts are utilizing certain rules. So, we are going into those particular rules and trying to understand as to how courts look at the laws, they make sense of those laws, and how this law gets applied to different situations. Because law remains the same, situations keeps differing, it keeps changing, and in different set of facts you have to apply the same law. You must have some tools in place to interpret, to understand, and that is what interpretation of a statute says. For your information, interpretation of a statutes is a full-fledged 4-credit paper in law programs. So they study the whole 60 hours, this subject, which we are going to cover in 2 lectures, right? So I think I will try to do justice to this. And I have seen your course material, about 40-45 pages of material. And I have tried to cover everything which is mentioned there in your course material in these 2 sessions, which I will be taking today. And I think next session we are going to have on 15th. So this is how we are going to deal with this subject, interpretation of statutes. Let me quickly go to our previous session, which was also relating to interpretation of statutes. And it was interpretation of statutes from a perspective of General Clauses Act. So major interpretation rules are incorporated as laws, and that becomes General Clauses Act. As we have seen, like for example, general rules of construction. So how to interpret gender and number, how to interpret the measurement of distance, how to interpret computation of time. These are the things which are mentioned in General Clauses Act. And whenever you are referring to the central legislation, central laws, you would like to refer to General Clauses Act for your interpretation. But what we will be discussing today is basically the more general principles which cannot be, made like a act or a rule, but it is a principle which has been laid down by courts in various decisions. And when you want to interpret them, when you want to interpret a clause or maybe make sense of a law, you look at these rules and regulations. So in General Clauses Act, we have seen, general definitions we saw. There were certain definitions, important ones, like for example, immovable property, oath, affidavit. These are the definitions we saw. Then we also saw about general rules of construction starting from section 5 to section 13. And then we discussed about the government functionaries, power and functionaries from 14 to 19, which basically deals with the mechanism of the government officials, their offices, how that needs to be, working, how successor will be appointed. If they have got the power of appointment, they have got the power of removal also. Whether they have got a power they can exercise once or many times. And such kind of things have been talked about in powers and functionaries. Then we also saw the provisions with reference to orders, rules, and what happens if there is a repeal of those rules, how the repeal of laws works. These are the things which we discussed in provisions as to orders, rules, etc. made under the enactment. And in miscellaneous provisions, we try to understand how there can be a recovery of fine in civil penalties, and what do you mean by service by post, and application of ordinances. So these are the things which we discussed under the General Clauses Act in the last two sessions. We have seen a plenty of questions also, and I'm sure by now you are clear with those particular questions. But if you have a specific question at this point in time, I will be happy to address and answer before I proceed with interpretation of the statutes. If you have any question with reference to General Clauses Act, please feel free to ask me. Any question, any point, any question, any clarification you would like to know on General Clauses Act. No questions? Can you respond on the chat box? If you don't have any questions, you can say it is clear to you all so that I can proceed. If there are any questions, then please put the questions so that I can address to you all. Okay, so it appears that you are clear with this General Clauses Act. Now let us move further. So under the interpretation of statutes, the learning outcome of this chapter says that after the end of this chapter, you should be able to gain some knowledge about the need for interpretation of statutes. Why do we require actually interpretation of statutes? You should be able to explain the various rules of interpretation of statutes, and you should also be able to explain or describe various internal and external aids to interpretation. Aids means help. So external help or internal help to interpret a law, that you should be able to do. And you should be able to comprehend the rules of interpretation of deeds and documents. So it is not only the interpretation of laws, but there is also a requirement of interpretation of deeds and documents. Either it is a sale deed, mortgage deed, or any kind of a deed, you have to do interpretation. Particularly, chartered accountants have to interpret these deeds. Either it is a gift deed, will, or any kind of a deed for taxation purposes, for incidence of taxes, for different other purposes from accounting angle, because all these different instruments are dealt with by the accounting standards in a different way, and hence you need to interpret whether there is a mortgage deed, and if it is a mortgage, then what kind of a mortgage it is, usufructory mortgage or maybe other kinds of mortgage. So this is something which you have to have it in mind when you are interpreting the deeds and documents. So these are the four major points which we are going to cover, and you should be in a situation to understand that. If you look at the overview of your chapter, the chapter would be covering introduction of relevant terms, and then we will talk about importance of interpretation of statutes. And in terms of rules of interpretations, there are primary rules and secondary rules. Today we are going to touch upon all these rules, and there are aids to interpretation. It is internal aids and external aids. So we will go into these internal aids and external aids to interpretation in our next class. And then we will see also the rules of interpretation of deeds and documents. Moving ahead, let us understand what do you understand by interpretation of statutes, deeds, and documents. So the first question which comes to your mind is statutes. So what is the statutes? When I say statutes means what? Statutes means laws and regulation of various kinds, irrespective of the source from which they emanate, right? So what are the sources from which the law can emanate? Can you people, type? From where do you think the law can emanate? What are the sources from which the law comes or statutes comes? Constitution, very good. Constitution is the Grundnorm. Vedant? And constitution is a place from where the constitution itself is a, basic law, and nothing, no law can go beyond constitution. This is what Article 13 says. But what are the other sources from which the law can come up? Ministry of Corporate Affairs, Achal says. Okay, fine. As a ministry, they can come up with rules. But what is the first source from where you see the law comes or statute comes or emanates? It is the parliament, right? So from parliament, the law comes up. Vishaka, very good. And after parliament, the law, the rule making power is given to the ministries. So different ministries come up with rules. And then laws may also emanate from different regulators, right? Like ICAI, IBBI. These people also come up with laws or, rules which can come up. And then authorities, executive authorities also come up with executive orders. And you have seen the definition of law under Article 13 of the Constitution of India. And it clearly says that law includes all these things, okay? Rules, notifications, orders. So statute laws, emanate from different sources. Law also emanates from customs, by the way. Customs and practices, that is also a source of law. Particularly in case of family law, in Hindu, we say customs is an important source of law in Hindu law. So different customs, and in mercantile law, that is business law, there are again some customs through which the law emanates. So this is a very important point. And statutes, we are talking about these statutes. So these statutes have some clauses, some text, and this needs to be interpreted, this needs to be understood as to what it is meaning. Okay. So this is about statutes. Then there are documents, and documents also need to be interpreted many times. Like, for example, there is a contract between two people. Now, contract may have many clauses, and you may be seeing that dispute arises many a times because there is a interpretation flaw between two parties. So you say, for example, A and B is having a contract, and contract is a document. This document, A is intending to understand in one way, B is intending to understand in one way, and that becomes a dispute. And this needs to be interpreted. What is the right position? And that is why people go to courts to get that interpreted and final verdict given that, okay, fine, this document means this, right? So this documents is also required to be interpreted. And Section 3 of the Evidence Act states that document means any matter expressed. And under the General Clauses Act also, we have seen the definition of document, right? So it means basically expressed on any matter, whether by means of letters, figures, marks, or more than of those means, will be referred to as documents. Then there are terms which is called deeds. So deeds are an instrument in writing or other legible representation or words on a parchment or paper. So generally deeds are drawn on paper. Deeds cannot be drawn on a vessel or a glass. But if there is something written on a glass or a piece of mobile, these are things which are called documents. But deeds are always drawn upon a parchment or a paper, as you can see in this picture. This is a kind of a deed. So, purporting to give effect to some legal disposition. So, if you simply want to say these are instruments, and all instruments, however, may not be deeds. In India, if you look at it, there is not much distinction between instruments and deeds. We use it interchangeably. But when I talk about deeds, deeds are like sale deed. That is a deed. If I say, mortgage deed. So these are different deeds. Deed of trust deed. So these are different deeds wherein the instrument, or you can say the document, decides the title between two people or transfer of property between two people, or gives right to someone, takes away right of someone. These are referred to as deeds. So all these three documents, these three situations, statutes, documents, and deeds, all require interpretation. All require because these clauses may be, having some complexity or maybe having a issue of interpretation, and hence these are all required to be interpreted by people who are dealing with it. And in most of the times, these are lawyers to whom these matters go, because if there is a confusion between two people about interpretation of any of these documents, a dispute arises. So dispute is nothing but a conflict on a position, and then you require a third party to adjudicate upon it, or you people settle amongst yourself. This is how the law works. Now, let us look at statutes. So we are primarily dealing with interpretation of a statutes, and interpretation of a statutes is a major part of, you can say, the interpretation subject. And when I say interpretation of a statutes, you have to understand that different statutes have a different way of interpretation. So I can give you a simple example. Like if it is a criminal or penal statutes, there is always a strict interpretation of penal statutes. Why? The philosophy of criminal law is that let 100 criminals go scot-free, but one innocent person should not be punished. This is what is the norm of criminal law. And hence, the evidentiary standard in criminal law is beyond reasonable doubt. So even if there is a small doubt to leave the accused, the criminal law does that. However, in civil law, it is preponderance of probability. It is not beyond reasonable doubt. So, broadly, they will look at it. Okay, fine, you have broad evidence, then a person can get the order in his favor or her favor. Again, if you look at the taxation statutes, they are again very, very strictly interpreted. So different types of statutes have a different standard of interpretation. So in this context, statutes are classified into different way. Now the classification which I have put in the slides are not there in your course material, but just try to understand them. And different authors have classified these statutes in different ways. So there is no one way to classify it. But try to understand the essence of each of these statutes and how interpretation works in these situations. So let us have a look at it. The first one. The first type of statute is codifying statutes. So purpose of this kind of a statute is basically to consolidate, or you can say to give authoritative statement of the rules on a particular subject with customary laws. So see, prior to Hindu Marriage Act 1955 or Hindu Succession Act 1956, the matters of marriage, divorce, succession were dealt with in the Hindu society without a law, right? And it was only a customs or practices by which people used to govern their marriages and this. However, when we got independence, one of the first agenda was that let us have a law which will govern or which will take care of these relationships. And that is where the codifying statute comes into picture. So this all codifying statutes or all customs and something which is by way of a, unwritten text are brought up as codifying, then that is called codifying statute. I can give you another example. IBC, Insolvency and Bankruptcy Code. What it has done, it has brought up various provisions under the Companies Act, scattered provision under the provincial insolvency law, and brought up all insolvency things together, and that is what it is referred to as Insolvency and Bankruptcy Code. So this is how the codifying statute works. In Hindi, we call it Sanhita. Right? So, like, for example, we have Bharatiya Nyaya Sanhita or Indian Penal Code, like that. Okay. Now, let us look at the another important category that is called consolidating statutes. So, this consolidating statutes basically combines all different laws or scattered laws into one singular way. And greatest example of consolidating statutes could be the labor codes. So you would have seen there are 39, more than 39 plus labor laws were there. they are now consolidated into 4 codes. So what you are doing? You are basically codifying them and consolidating them. So there is no difference, much difference between codifying and consolidating statutes. Just for your understanding, you can understand that when we say consolidating statutes, it is consolidating various laws into one common law. Now let us look at another one. So this is basically called declaratory statutes. So there are statutes which are there to remove certain doubts, or they are there to clarify or improve the law on the basis of interpretation given by courts. Like, for example, Income Tax Amendment Act of 1985 provides the definition of house property, right? And it has amended the definition of house property through the judgment of Supreme Court, following judgment of the Supreme Court. So these are all declaratory statute. So court has already said certain thing and that becomes the law. However, the law declares it expressly into that okay, fine, this is the law. Like, for example, in Supreme Court, there was a decision on Vishakha versus State of Rajasthan. So that was a law which actually established, Supreme Court came up with the guidelines on prevention of sexual harassment of women at workplace. Now, those were guidelines. But later on, these guidelines were declared as a statute under the Prevention POSH Act. You people may be knowing about it. So this is declaratory statute. Then there are certain remedial statutes. So remedial statutes are the statutes wherein they provide for certain remedy, or these statutes are made for promoting welfare of people. So nature of remedial statute is such that whenever there will be an interpretation of remedial statutes done, there the court would be liberal. They will be towards welfare. Like, for example, if there is an interpretation of Maternity Benefits Act, the courts most of the times have interpreted in the benefit of the mother. Similarly, Workmen's Compensation Act, Consumer Protection Act, these statutes are remedial statutes, and hence the courts have always utilized a liberal interpretation in interpreting these terms or these statutes in favor of the people for whom the law has been made. I hope this is clear to you, remedial statute. Then there is a statute which is referred to as enabling statute. So this enabling statute idea here is that it enables the government to do certain things. Like, for example, Land Acquisition Act. It enables the government to acquire the land for public purpose, right? Similarly, Administrative Tribunals Act. It enables the government to establish administrative tribunals. These are called enabling statutes. Now you may see one legislation may have many of these characters together also. So say, for example, in most of the legislations, you have some enabling clauses or enabling sections. Like, for example, in Competition Act, you have the enabling clause by which you form the Competition Commission of India. You have the enabling clause wherein you enable the Competition Commission of India for making regulations. So these are all called enabling statutes or enabling provisions. I hope this is clear to you. Then we are having some law that is called disabling statutes. So it is basically the opposite of what the enabling statute does. Here, you are prohibiting people from doing certain things. Like, for example, Child Law Prohibition and Regulation Act. So it prohibits you from doing it. UAPA, it prohibits you from doing certain things. Like that. This is what is called disabling statutes. Okay. Makoka, or maybe smuggling laws, or maybe FEMA provisions, which disables you from dealing with foreign exchange without permission, right? So these are all disabling statutes. I have already touched upon about the penal statutes. They are very strict in interpretation, and you need a evidentiary standard which is very, very high. Then we have taxing statutes. Taxing statutes levies taxation. So tax is a form of revenue, you all know, which has to be paid to the government. So it can either be on income or on any other transaction. And a taxing statute thus levies taxes on all such transactions. There can be income tax, wealth tax, sales tax, gift tax, etc. Therefore, a tax can be levied only when it has been specifically expressed and provided by any statute. So, the courts have been very, very strict. You cannot impose tax just for the sake of imposing taxation. You have to have the powers. Central government must have power. State government must have power to impose a tax on, and without that power, you cannot. So, Constitution provide the power to impose tax. These are taxing statutes. Then we have certain statutes which are called explanatory statutes. And one of the greatest example of explanatory statutes would be General Clauses Act. So we have seen General Clauses Act, what it tries to do. It is not creating any right or it is not creating any liability. It is basically created for explaining the terms. So by General Clauses Act, they explain, the statute explains certain things. Okay. Then we have amending statutes. So the statutes which operate to make changes in the provisions of enactment to change the original law, these are referred to as amending statutes. So there are many amending statutes, like for example, we can say Companies Act or Insolvency Bankruptcy Code. You saw there are many amending statutes by which the Insolvency Bankruptcy Code provisions have been amended from one law to another law to another law, right? The last one is repealing statutes. So repealing statutes is one which terminates an earlier statute and they come with a new statute, like for example, Competition Act repealed the provisions of MRTP Act and it brought up a new mechanism. So repealing statutes have a way of being dealt with. And this we have also seen in section 6, 7, 8 of the General Clauses Act, wherein we saw the norms of interpreting the repealing statutes. So these are different types of statutes which we can, understand. And as you would note that interpretation of these statutes would accordingly differ as per the nature of that particular statute. So before we move on to the next one, you have any questions on this part? Any questions on the types of statute or any observations, any one of you? Yeah. Any observations or any questions? Seems you don't have any question. Okay, so we'll proceed further. Achal, what you would like to understand out of this? Because there are many statutes which I explained. Which one you want to understand? Consolidating statutes. So consolidating statutes basically consolidates various legislation together. Like for example, if we are talking about, Indian Contract Act, that is also a consolidating statute because it consolidates the all previous laws and brings it together. Consolidating statutes, if I look at it, there are legislations like, for example, RERA, Real Estate Regulatory Authority. That is also a consolidating statute because there were many other legislations which were dealing with this. It is consolidating it into one. So that is the nature of consolidating statutes. Okay, now let us look further and talk about classification of interpretation. So this is given in your course material. So the general classification of interpretation can be done into two parts. One is legal and the other one is doctrinal. So when we say legal and doctrinal, there is a jurist called Fitzgerald, and he basically defines them as literal and functional. So when I say literal means word to word or black letter. Whatever is written, you interpret as it is written. You don't have any scope of changing the meaning of this. When we talk about functional, we are discussing about the purposive interpretation. So you want to make sense from that particular text and don't apply that particular law senselessly. This is what is the difference between literal and functional. But in your classification, in your course material, the distinction is between legal and doctrinal. So when I say legal interpretation can be authentic or it can be usual. So interpretation is authentic when the rule of interpretation is derived from the legislator himself, right? Like, for example, the legislator has made a law and it interprets it or explains it, giving the explanation clearly itself. That will be an authentic interpretation. I can give you two examples wherein you will find such kind of a law. The one is basically the. Give me a second. The one is the DPDP Act. So if you see DPDP Act and DPDP rules, the DPDP rules gives sufficient amount of explanations and illustrations. So this is something which is coming directly from the legislature. Legislature is trying to give you the interpretation themselves. So if that is the situation, that becomes authentic. Or say, for example, there is a law and a query comes up, and this query is directly answered by the parliament, then that will become an authentic interpretation. But for your information, this does not happen because it is the court's job basically to interpret, and they interpret it rather than parliament themselves giving some interpretation. Then there is an interpretation which is called usual interpretation or under legal interpretation. And this is a situation where you look at some other source, like for example, customs, or you look at the case laws by this court, and then you try to derive the rule of interpretation. That is called usual interpretation. So in legal field, most of the times you will find legal usual interpretation. So either you will go ahead with a case law, you will see the court cases or something wherein the decision has been given by the higher courts, and you will try to see how that has been interpreted. Or you will look for to a established custom to establish your case that, okay, fine, it has been, done time immemorial and it is not contrary to the moral policy of the society, and hence this should be interpreted in a particular way. Then we are having this doctrinal interpretation. So doctrinal interpretation, if I look at it, doctrinal interpretation basically are of two types again. One is grammatical interpretation and the other one is a logical interpretation. So when I say grammatical interpretation basically says that when the courts, so if you look at doctrinal, you can consider it as a part of legal usual, okay? So doctrinal, grammatical portion is a situation where the court applies only the ordinary rule of speech. Ordinary rule of speech means what? Whatever is written, you just follow whatever is written. You don't supply any word or anything. And whatever is written, you apply that only. It is called black letter law. However, there are certain logical requirements. So the logical requirement is when the court goes beyond the words and they try to discover the intention of the statute, or they try to understand the meaning of the statute, why the statute has come up, what mischief it is going to cure. If all these things court is doing, then it becomes a logical interpretation. So in the doctrinal interpretation, courts can do two ways. As Fitzgerald says, either it can go ahead with literal interpretation, that is called grammatical also, or it can go with a functional approach or a logical approach. That is what would be referred to as, logical or functional interpretation. I hope this difference is clear to you. When I say legal, we are talking about the source. Either it can be legislature itself, which is authentic, or it can be the court, or it can be custom, which is usual. And when courts are applying the interpretation or dealing with the interpretation, that will be referred to as doctrinal. And there, when they are applying the black letter law without ordinary speech, that will be referred to as grammatical. And if they are making sense of that particular interpretation with some more words or some, what you can say, some more analysis, then that will be referred to as logical or functional interpretation. I hope this is clear to you people. Let me further talk to you in this. This is something which is already written in your book. You can have a look at it. Interpretation usually said to be either legal or doctrinal. It is legal when there is an actual rule of law which binds the judge to place a certain interpretation of the statute. It is doctrinal when its purpose is to discover real and true meaning. Legal interpretation is subdivided into authentic and usual. This we have already seen that. And doctrinal may be again divided into grammatical and logical. So I hope this differentiation is clear. Any one of you would like to ask any question till this point on distinction between the general classification of interpretation? You may have a question on general classification of interpretation. Yes. Any questions on this particular slide specifically? This is talking about difference between interpretation. Yes. Any one of you can ask. If there are no questions, then we can proceed. If you have understood everything. Are there any questions? Okay. Thank you, Gayatri, for that input. Now let me move further. And now we are talking about a distinction between the term interpretation and construction. So you must have heard this particular word interpretation, and sometimes you would have heard the word construction. If you look at the General Clauses Act, it is talking about general principles of construction in section 5, right? So what is the distinction between them? So the Latin term interpretari, which basically means to expound, understand, or translate. So it is interpretation is coming from there, right? So interpretation, if I have to define, it will be interpretation is the process of explaining, expounding, and translating any text or anything in written form, right? Now, this basically involves an act of discovering the true meaning of the language which has been used in the statute. On the other hand, when I say interpretation, Salmond has defined interpretation, and he says Salmond is a jurist, by the way. In interpretation book, you will find his name very often. He defines interpretation as saying that it is the process by which court seeks to ascertain the meaning of the legislature through the medium of authoritative forms in which it is expressed. Another jurist, Cooley, defines interpretation, and he says that interpretation differs from construction. How? In that the interpretation is the art of finding true sense of any form of words, that is, sense which their author intended to convey, and of enabling others to derive from them the same idea which the author intended to convey. Whereas construction, on the other hand, is drawing of conclusions respecting subjects that lie beyond the direct expression of the text from elements known from the letter of law. So it is basically telling you that construction means interpretation or making sense of that particular text which is there, legal text which is written there. However, in India, if you look at it, we use this, as a common usage, both the terms, we use it as interchangeably. So that is why it is said interpretation and construction are usually understood as having the same significance in India. Now we are moving to some basic principles of interpretation. So there are four basic principles of interpretation which you should keep in mind. We will go to the specific rules also. But before we go to the specific rules, that is primary and secondary rules, and the internal and external aids of construction, let us look at four basic principles. So which are the four basic principles? The first basic principle is intention of the legislature. That is the primary one. Whatever law is being made, who makes the law? Legislature makes the law. For whom the law is made? For the people. Who authorize the legislature or the parliamentarians to make? People. So it is the government by the people, for the people, of the people, right? So who gives the mandate to the legislature to make laws? It is the people by voting. And these people go to the legislature and they make laws for whom? For the people. So intention of the legislature is very, very important because they would only know that what for the law has come up, for whose benefit the law has come up. This is very important. So intention of the legislature is the basic principle which comes. I will deal on intention of legislature a bit more because in most of the cases or case laws which you will read on interpretation, Supreme Court has labored a lot in explaining intention of the legislature. Wherever you go, whenever there is a question of constitutionality, whenever there is a question of interpretation of a statutes, the point which will come up for consideration of the court would be intention of the legislature. Then the second point which comes up is it says that statute must be read as a whole in its context. So you cannot pick and choose. As it happens nowadays in media reporting, they pick and choose. Okay, I only want your one statement, not the whole thing. So reading of a statute must be done as a whole. You cannot just pick up 4 or 5 or 7 clauses and then get away with it. It is not possible. You have to read all these as a whole in the context. Third rule of interpretation says that if meaning is plain, if in a plain language everything is clear, effect must be given to it irrespective of the consequences. So you should not worry what will happen if we apply this particular law. If law is existing, the language is plain, you have to apply that particular law. You should not worry about the consequences as to what will happen. I can give you a brief example of this. Recently, you must have noticed in, I think, Bihar, there was a person who has been put behind bars for a murder trial after 33 years. Right now, the person concerned is about 88 years and he has been imprisoned for 3 years and he has been sent to jail. Now you may give a if and but logic, right? That he is old, this has happened, that has happened. But the person, the judge who has decided this particular case has gone to interpret the law by this third principle, which clearly says you don't look towards the consequences. You look towards the plain meaning. Plain meaning says that if for a murder and for that particular trial, this much is the punishment, the person has to go ahead with that particular punishment. So this is the third rule. If meaning is plain, effect must be given to it irrespective of the consequences. The fourth basic principle, and which is an important principle, it says that statute to be constituted to make it effective and workable. This is a very peculiar situation. So law has come up, but law doesn't give sufficient clarity for interpretation. So what do we do with this law? Can we delete this law? Can we take away this particular law or ignore that law? No. The courts are meant for that purpose itself. The legislature will not sit again and again over the law. They would try to make sense of that law by interpretation. You would recollect my point on may and shall. So if the statute says shall, but shall is not workable, then you interpret as may and then make it workable, right? So this is what basic principle, fourth basic principle says, that you don't discard the law as such because it is, not workable. You try to make it workable. And this is what is the fourth principle. So it is in order basically. So you start with intention of the legislature. You see what legislature meant. Second, you see statute as a whole. You don't see it in parts. Third, if the language is plain, you just apply it. You don't worry about the consequences. Fourth, if there is some confusion or ambiguity, you try to make sense of that particular law. So these are the four main principles of, interpretation. Any question till this point? This one, this four rules, have you got it? Have you got the clarity? Construe. Yes, Daksh. Construe means to interpret. Okay. The statute to be construed. Construed means to interpret, to make it effective and workable. Okay. So construe means to make a meaning out of it. Right. Yes. Any other question till this point? Okay, fine. If it is clear, then let me proceed further. Then now let us move ahead with one of each principle will go one by one. But before we go into one by one, let me give you the logic of why we are talking about interpretation. We are talking about interpretation because everything is not black and white in law, right? So you cannot say that it is mathematics. Nowadays, by the way, in mathematics also, they are saying 2 plus 2 is equal to 5 because they are trying to build synergy into it. So law is not black and white. There is always a twilight zone which needs interpretation and construction. And hence there is a requirement of interpretation. So let me take about a question that how do you distinguish between day and night? So everybody knows, day and night. But the challenge happens between the twilight zone. So if you look at the twilight zone before the sunset and after the sunrise, now I think it is 6:48 and still outside I think there is light. Can we say that it is night now? Well, that is a question, right? I don't know if you are operating a GPS, probably it will show as dark night because 6 p.m. for them it is night. So you have to see the context. If you say, for example, there is in UK, there is a daylight saving. So 1 hour, there is a distinction between that. So that is basically, you have to see the things in context. And hence, interpretation is required. I can give you one example. In CRPC, the woman cannot be arrested after sunset or before sunrise unless there are exceptional circumstances. This is written in section 46(4) of the Criminal Procedure Code. So when do you decide that it is sunset or sunrise? On the basis of the lightness, or you look at that particular watch on that particular day, what is the time given of sunset and sunrise? This is something which requires interpretation, and courts have interpreted actually. If you look at in the case of Sheila Barse versus State of Maharashtra, 1983, Supreme Court laid down clear guidelines for police while arresting women. And they have to tell that how you will deal with it. So I am just trying to make a point that in law, there will always be this twilight zone where there will be a requirement of interpretation. And that is why the importance of this particular subject. Let us look at the first principle, that is intention of the legislature. So what is the intention of the legislature means? So where do you find the intention of the legislature, by the way? You have any idea? Where do you find the intention of the legislature? How do you come to know that this is the intention of the legislature? Any ideas you people have on intention of the legislature? Yeah. Lok Sabha. Okay, no, but where do you find the intention of the legislature? Say, for example, there is a law like insolvency and bankruptcy code is there. So you people all must have read it, right? Or maybe company law is there. And there is a provision with reference to independent directors. So where do you find the intention of the legislature? Circulars for clarification? No. Intention of the legislature, where do you find? It's a very interesting question. Yeah. In court? No. How you find the intention of the legislature in court? How can you find it in court? Court interprets, but where do you find the intention of the legislature? Court finds that, but again, every time there is no need for going to court. Good, Sushmita. So preamble you have said. So preamble is one area where you can find the intention of the legislature. Vedant says objective. Yes. So objects and reasons of that particular law also gives the intention of the legislature. So in every law is preceded by objects and reasons. So you will find that at the floor of the parliament, whenever there is a new law introduced, they will give the reasons why this law is coming, right? Any law you talk about it. If you see the preamble, that will tell you the reason why the law is coming, what is the necessity. Further, the provision itself tells, if you read the provision carefully, it tells you what is the reason for having this. And if it doesn't tell, then you interpret, you try to find a meaning out of it. So intention of the legislature is basically the principle which is central to statutory interpretation. And it reflects the judiciary's role in understanding and implementing the laws the legislature intended. So you cannot go beyond the intention of the legislature. And it is founded on the premise that every law enacted by a legislature has a purpose, and interpreting the statute in alignment with that purpose is essential for justice and effective governance. So the intention of legislature basically refers to the objective or purpose the legislative body sought to achieve when enacting a particular statute. It is guiding principle for interpreting statutes to ensure their application aligns with legislative will. So this is the idea of intention of the legislature. So in the case of Narayana Swamy versus Panir Selvam, the Supreme Court said that duty of the legislature is to act upon the true intention of the legislature, that is the mens or sententia legis. So this has been held in Institute of Chartered Accountants of India versus PricewaterhouseCoopers also. In these cases, courts have held that you go and find out the intention of the legislature. What is the intention of the legislature? In this ICAI versus PwC case, there was an issue with reference to NFRA. And the discussion was whether the NFRA has got sufficient powers to regulate illegal activities in the accounting sector or fraudulent activities in the accounting sector. And the court looked at the intention of the legislature of framing of NFRA, why NFRA came up. And they said that legislative will was to have a authority which will look at these fraudulent activities. So this is how you look at the intention of the legislature. So intention of the legislature, I hope, is clear to you. Someone raised the hand. If you have a question or a comment, you can make it. Isha, I think. Yes. Yes, Isha, you want to speak or it was by mistake? Okay, it appears it was by mistake. Let us move further. So Lord Denning is a very renowned figure, and Lord Denning is a jurist who was in UK, and he has given many decisions. And these decisions, one of the decisions, he has talked about the intention of the legislature, and he said very specifically that English language is not an instrument of mathematical precision. So when you see a statute or when you see a provision, you cannot with mathematical precision say that this means that. And Lord Denning says that our literature would be much poorer if it would have been mathematics. And that is true because we use so many different words for different synonyms, antonyms, and all these things. That is why the Lord Denning says a judge believing himself to be fettered by the supposed rule that he must look to the language and nothing else laments that the draftsmen have not provided for this or that or have been guilty of some other ambiguity. It would certainly save the judges trouble if Act of Parliament were drafted with divine prescience and perfect clarity. This is a utopian idea. You cannot have perfect clarity in legislating everything. You can even not have perfect clarity in drafting contracts. Probably that is why there are disputes, which happens. If you have that much of a perfect clarity, there was no need for having disputes, right? So in absence of it, when there is a defect, judge cannot simply fold his hands and blame the draftsman. He has to cure that particular mistake. And that is where he has to go back and see what is the intention of the legislature. What is the problem the law wanted to solve, or we call it as mischief, addressing the mischief, right? So please have a look at this particular quotation from that act. Let me now take you to another part in another case. And in Aaron Solomon versus Solomon Company, the House of Lords observed that the intention of legislature is a slippery phrase. So you cannot park everything in the name of intention of legislature. So what the legislature intended can be legitimately ascertained from that which it has chosen to enact, either in express words or by necessary implications. As I said you, where do you find the intention? In the text of the law. The construction which furthers the purpose or object of an enactment is described as purposive construction. So the courts have always tried to look at the law from a literal perspective first. So purposive construction is a situation where first you go ahead with the literal interpretation. This is the basic rule. So whatever is written, you read it and you make a sense out of it. But if it is not making sense, if you recollect our fourth rule, fourth principle that talks about the law needs to make workable. This is where applying a strained meaning where the literal meaning is not in accordance with the legislative purpose, there comes the purposive interpretation you have to do, and you have to interpret the law to make some sense out of it. So purposive interpretation is, an important requirement. And in case of Vivek Narayan Sharma versus Union of India, this is a case which dealt with demonetization. So in the case of demonetization, the court majority applied the purposive interpretation, right? And here the court in para number 139 said that our own court has generally taken the view that ascertainment of legislative intent is the basic rule of statutory construction, and that a rule of construction should be preferred which advances the purpose and object of the legislation, and that though a construction according to plain language should ordinarily be adopted, such a construction should not be adopted where it leads to anomalies, injustices, or absurdities. So court referred to these many cases, and court said that there is a requirement of a purposive interpretation. In this case, demonetization case, I will tell you what was the issue. There was a requirement of consultation with government. So whenever a government notifies a demonetization, there is a requirement of RBI to be consulted, or RBI recommends that particular exercise, and that has to be done in coordination with RBI. In this case, Justice Nagaratna wrote a dissenting opinion, and it said that government first took a call on demonetization, it gave the order, and later on consulted with RBI. And as per her, the process should have been that RBI should have initiated the point, government should have agreed to it, and then demonetization should have happened. So majority view in this particular case said that you have to look at the intention and purpose. What was the purpose? Purpose was to have demonetization. Whether government consulted RBI? Yes, it consulted, not prior, but later. And whether both of them were on same page as far as demonetization is concerned? Yes, they were on same page, and then demonetization was ordered. So this is something which was called as a purposive interpretation. So you have to go to the intention, why there is a need for this law, and whether that has been purposefully fulfilled or not. So Justice Nagaratna in this particular case actually went into a literal interpretation of rules, and that is where she has given a dissenting opinion, and Justice Gawai and I think few more judges have given the majority opinion in demonetization case. So interesting case, you people may read it. Now let us talk about another important jurist on jurisprudence, and that is Craze. So Craze on legislation has authored a book on jurisprudence, and he says legislation is always to be understood first in accordance with its plain meaning. So whenever there will be an exercise of legislative meaning or legislative interpretation, you don't look at any rules. You don't require any primary, secondary, or internal or external aid of construction. You have to just first read the provisions. Whatever provision of law is there, you read it simple language. And if it is making sense, you stop there and apply the law. There is no need for you to, search for more meanings into it. Where the plain meaning is in doubt, the court will start the process of construction by attempting to discover from the provisions enacted the broad purpose of the legislation. And this is the place where you will look for intention of the legislature. Otherwise, if the plain text is clear enough to explain, there is no need for you to go into the interpretation exercise or construction exercise, right? Now, where a particular reading would advance the purpose identified there and would do no violence to the plain meaning of the provisions enacted, the court will be prepared to adopt that reading. Now, where a particular reading would advance the purpose identified but would strain the plain meaning of the provisions enacted, the result will depend on the context. I told you before in my previous class that context is the king. So interpretation will happen where? Interpretation will happen in the context. So there has to be a balance of the clarity of the purpose and degree of strain on the language. So just because you want to interpret a law in a particular way, you cannot change the law. The courts don't have power to change the law. The court have power to interpret the law. And hence, you cannot strain the things too much. And where the courts concluded that the underlying purpose of legislation is insufficiently plain or cannot be advanced without an unacceptable degree of violence to the language, they will be obligated, however regretfully in the circumstances of a particular case, to leave it to legislature the task of extending or modifying the legislation. And the courts have done this, by the way. Courts have left the issue for the legislature to be done with. I can give you an example, like Uniform Civil Code. The courts have not given any judgment on that. It said that, okay, it is left to the, legislature to look at it. Same-sex marriage. This was, brought before the court. And it was said that under Article 21, you read this. But court said that, no, the law doesn't say like that. Let it be left to the, legislature. Let them come up with a law. We cannot, bring that particular law. So these are some of the examples where the courts have refrained from interpreting or doing violence to the language of the law. I hope this gives you a bit of an understanding. I am conscious of the fact that you people are not from law background, and probably certain things you may be finding a bit heavy, but try to understand that everything rests on the four principles which I just discussed with you people, and these discussions we are having it there. Now, let us look at the basic principle, the second one, which talks about that statute must be read as a whole in its context. So what does this mean? It is saying basically that you don't pick up the statutes separately. So in the case of Union of India versus Elphinstone spinning, the court said when the question arises as to the meaning of a certain provision in a statute, it is not only legitimate but proper to read that provision in its context. So the context means what? Context means statute as a whole. The previous state of law. What was the situation before this law came into picture? Other statutes which are there in pari materia. If similar kind of statutes are there, what is happening there? And the general scope of the statute and the mischief that it was intended to remedy. And that is where the mischief rule came up, that all legislation, by the way, for your information, has come up to solve some problem, right? And that is called mischief. No law is there to just for the sake of it. Any law you pick up, there must be some problem for which the law has come to address. And that particular mischief needs to be cured, right? This is what was held in Union of India versus Elphinstone spinning. So Lord Davey said that every clause of a statute should be construed with reference to the context and other clauses of the act, so as far as possible to make a consistent enactment of the whole statute or series of statutes relating to the subject matter. It is spoken of construction ex vesiribus actus. To ascertain the meaning of the clause in a statute, the court must look at the whole statute, at what precedes and then when succeeds, and not merely the clause itself. So you look at everything. You look at the definition clause, you look at the provision, you look at the repeal clause, you look at the whole statute to make sense of the legislation. So in one of the cases before the Supreme Court, that was Tulsamma versus Shesha Reddy, 1977, the court observed it is elementary rule of construction that no provision of a statute should be construed in isolation, but it should be construed with reference to context and in the light of other provisions of the statute, so as far as possible to make a consistent enactment of the whole statute. Similarly, Sinha CJI in State of West Bengal versus Union of India said the court must ascertain the intention of the legislature by directing its attention not merely to the clauses to be interpreted, but the whole legislation, the complete legislation. You should look at it. Like, for example, if you have to read independent directors, you have to see whole corporate governance scenario. Then you can have the interpretation. You cannot just pick up one provision on independent director and interpret the whole corporate governance. No, you have to see what is the utility of having independent directors. What is the purpose of having independent directors? Say, for example, you are making an interpretation on vigil mechanism. You have to see the whole context. Why vigil mechanism is there under the Companies Act? To see that there are no accounting violations or accounting frauds which happens. So this is the context. So you have to look at it. And here the role of judges are very, very important. So judges have to actually examine, and there is a lot of, what you can say, reliance on the judges, and the judges have to actually go into the detail of it and try to strike a balance between letter and spirit of the statute. And this judges do. So the duty of a judge is to expound and not to legislate is the fundamental rule. So the judges are not supposed to legislate themselves. What is their job? Their job is to interpret. They cannot lay down a law. And there is no doubt a marginal area in which the courts mold or creatively interpret legislation. However, they are refiners and polishers of legislation. They cannot create a legislation. This is what is very clear. By no stretch of imagination, a judge is entitled to add something more or take away something from a statute. So therefore, the cardinal principle or rule of construction is that the true or legal meaning of enactment is derived by considering the meaning of words used in the enactment in the light of the purpose or object which comprehends the mischief. Okay. And you have to apply these principles. And Bombay High Court has dealt with, many other courts have dealt with. So I would basically tell you that please read briefly about this, and I will not labor much on that. Any questions till this point? I see some legislate. Legislate means to enact or to what make the law. That is called legislate. So courts are not supposed to legislate. They cannot make laws. They have to interpret the laws. What is discernible? Discernible is basically meaning. Like what is the meaning? What can be understood from that text? That is called discernible. Daksh. I think this is clear. Any questions? Any other questions till this point? Any one of you? Okay, you people don't ask any questions. Very less questions you have. Okay. Now let us move further and talk about another basic principle. But I think before we move on to this basic principle, let us take a break. Okay. So we meet in 10 minutes now. So it is already 7:11. So 7:21 we begin.
Good evening, students. Okay, so we have come to the end of our sessions for the upcoming September 2026 examinations and your January 2027 examinations. So, students who are preparing for this September 2026, I hope so. You guys are ready and your preparations are going in for full swing. I just wanted to know from few of you that how are the classes going, just give us the feedback. And one more important thing that I would like to bring to your notice is that are the sufficient number of classes fine for all of you? So give your feedback with respect to the number of classes in terms of our respected faculty members, as well as if you want any changes for the classes. So do give us the feedback. The students who have logged in from the mobile app, uh, there is the feedback form, and those who have joined through the knowledge portal also, they can just go through. At the end there is a feedback form given. Request you to kindly give your feedback. It will help the institute to pick out the right things, enhance them, and if there is any improvement needed, then we will go in for that also. So do give us your feedback. And one more, good evening, sir.
Hi, good evening. Good evening. Yeah, please continue with your. This is very important. Feedback is very important, students. You should give the feedback because that will not only help you but also to the future batches, and this always helps us in course correction. So please do that. Over to you, madam. Please continue.
Okay, okay, sir. Thank you, sir. And students, Daksh, you are asking that why there is not any LVC separately for Jan 27. See, this batch is catering to both September 26 as well as your January 2027. If we have a batch for January 2000 separately, then it will be like overlapping. However, if any student like this batch was catering to September, then Jan 27 and May 27. But we are having a new batch for May 27 also. So if any of the students who are attending the class and they want specifically for May 27 and onwards, then they can see that batch also. And then that batch will be having the DTC code, the new Income Tax Act 2025 also. So if you know anyone or if any one of you is planning for the May 27, then you should attend that batch. And Dhyani Shah, I will just talk to my technical team that what's the problem with the mobile app, and it should be sorted because generally if there is something, then the technical team resolves it then and there. Okay, Achal, ma'am, but we registered in April, so the syllabus is already ahead for Jan 27. So are you appearing for Jan 27? The syllabus is not ahead for Jan 27. It is giving you the right kind of preparation time to you guys. See, we are in June right now. So July, August, September, October, November, December. 6 months of preparation for you is there. Then we will be having a separate LVRC, which is your live virtual revisionary classes that will be held for January 27, wherein whatever the teachers that have taught you here, we will be practicing again and again through questions. So you read, you have done the classes right now, and then again you keep on revising on your own, and then in the around October to November, we will be having a January LVRC batch for January 2027. So that's giving you a right amount of time as well as your preparation will be good. I hope so. Now it's clear. Okay, but what if we started after the results were out in March? You are asking for which attempt, Daksh? We were in a delay. January 27, how? But what if we started after the results were out in March? We were in a delay of 2 months as per concerned calculations. Ma'am, okay, 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 okay. So you are saying that for January 27th, some of your topics are already done away with. So what you can do is, we are again starting a batch on I think 13th of July. Okay. So a new batch is starting from 13th of July. Subjects that you may have missed, either you can go in for the recorded lectures of the current batches that are going be- prior to March, or you can see the new lectures that will be going on live. Okay. So provision is there as per your convenience, and LVRC for September 26 will start on I think 24th of, like, end of July. No, no, no. Sorry, sorry. I'm really sorry. September 26th, LVRC will start from 15th of June. I'm really sorry, Sridhar. 15th of June 2026, your LVRC will start. I hope it's clear. So, with this, I request you again to please fill the feedback form, and I hand over the session once again to sir. Over to you, sir. Thank you. Thank you, Daksh.
Yeah, thank you. Thank you. Those were very important announcements, and I think you people need to prepare for your examination, and preparation has to be strategic. That is because these are all competitive examinations, and you need to be very, prepared thoroughly with whatever information is made available to you. And asking questions is also very important, and preparing yourself for the lectures and themes and everything is very, very important. So let us begin. Let us continue with our discussion, which we were having. And we are having these sessions on General Clauses Act and interpretation of statutes in two phases. So we already discussed General Clauses, Act in two sessions, and we had clarified the doubts. Still, if you feel that there are some doubts which will be remaining after this class as well, on 15th, I'm going to have your session again, and that will be the last class for interpretation of statutes. So you can ask any questions. So bring all the questions which you have, all doubts which you have. I will be happy to explain you all of them. Okay. So let us now proceed, and we are talking about the principles. Okay, so four principles we saw about interpretation of statutes, and the first one was that to look at the intention of the legislature, and we have seen that why and from where you get the intention of the legislature. So you have to first see the text of the law, which gives you the intention of the legislature. If text is not explaining you the intention or giving you the intention, then you go into the depth of it or deep and try to find out the purpose of the legislation. This is how you deal with the law, right? So another basic principle is the second basic principle, which is a third basic principle, is basically that you have to make the statute effective and workable. So your statute has to be construed in a way that you make it effective and workable. So let us understand this by way of an example. So in a case, the question was that whether section 28(1) read with 18A(9) of the Act, it is competent to the income tax authorities to impose a penalty on a person who has failed to comply with section 18A subclause 3 of the Act. So you have to just see that what was this legislation. So there was a legislation which basically brought section 18A, and the object of bringing this was that the SSEs were failing to submit the estimates under section 18A, and here the court looked at the maxim ut res magis velit quam perit, and they said the construction which leads to such result must, if that is possible, be avoided on the principle of express maxim, that it is better for a thing to have effect than to be made void. So it is trying to say that we understood, right? So that statute should not be just discarded. You need to try to make sense of that particular statute and try to make use of that statute. So in one of the cases, in Curtis versus Stovin Fry, the court said that the only alternate construction offered to us would lead to this result, that the plain intention of the legislature has entirely failed by reason of a slight inexactitude in the language of the section. So if we were to adopt this construction, we should be construing the act in order to defeat its object rather than with a view to carry its object into effect. So see, when the court will be faced with a situation, one interpretation actually kills the statute and another interpretation keeps the statute live and workable, court will go ahead with the workable solution, right? So, and they will also recommend for any amendment or anything, and they will say that, okay, fine, legislature should amend this or take care of this, but they will try to find a solution. I can give you an example. Section 89 of the CPC, that is Code of Civil Procedure, right? So Section 89 of Code of Civil Procedure provides for alternate dispute resolution mechanism, right? And it lists arbitration, mediation, lok adalat, all these things are mentioned. So there the question came up for interpretation between mediation and arbitration. So by mistake, probably by the legislature or by anything, the clauses were substituted. So the meaning which was to be given for judicial interpretation got into mediation, and the clause where mediation explanation should have been there, it got into judicial interpretation. So the court looked into this issue and they tried to solve the problem rather than just discarding Section 89. So this is what this principle says. This principle says the statute has to be construed to make it effective and workable rather than just destroying it. So, craze on statute law also says that to be workable and the interpretation thereof by a court should be to secure that object unless crucial omission or clear direction makes the end untenable. So this is how the, court looked into it, and they said that it was competent to the income tax authority to impose a penalty under Section 28 if there has been a failure of compliance under Section 18A3. So this is the case of Commissioner of Income Tax versus Teja Singh, 1959. So principle is that you always try to make the statute workable rather than just, discarding it. Another basic principle is that if the meaning is plain, you give effect to that meaning irrespective of its consequences. Okay, whatever may be the consequences. And this is a well-settled principle of law, that statute has to be, interpreted irrespective of the impact which it has on the, people. So the intention of the legislature assimilates basically two aspects. One, the meaning, that is what is the meaning of that, law, or what is the purpose or objects or reason of that particular law. And the process of construction, therefore, has to combine both liberal and purposive approaches. So, however, necessity of interpretation would arise only when the language of the statutory provision is ambiguous. If language is plain, language is clear, there is no need for you to do interpretation. It is clear enough. But when the language is having some complexity, or language when is not making any sense, or you are finding difficulty to make sense out of it, then you look at the interpretation. So this is what is referred to as the Sussex Peerage case. And this case came into a question where the rule for the construction of Act of Parliament is that they should be construed according to the intent of the Parliament which passed the Act. If the word of the statute are of themselves precise and unambiguous, then no more can be necessary than to expound those words in their natural and ordinary sense. The word themselves do, in such cases, best declare the intention of the legislature. Let us look at with Rahul Gandhi's case. There was one case which came up, and there was very literal interpretation where the language is plain. You don't have to go into the much detail of it. So you may be knowing on April 16, 2019, one MLA Purnesh Modi filed a criminal defamation case in Surat under Section 499 and 500 and 504 of IPC against Mr. Rahul Gandhi. And he claimed that his remark was against the entire Modi community and it defamed. And in May 2019, the Chief Judicial Magistrate Court at Surat registered the case, right? And after the hearing, and it was found that Rahul Gandhi violated the law, and there the Chief Judicial Magistrate at Surat gave a penalty or punishment for 2 years. And in High Court also that punishment was upheld in Gujarat High Court. Now see, there is a provision under the parliament where it says that if someone is punished for 2 years or more, then that amounts to disqualification of the member of parliament from his position. And here, as soon as the judgment came of the High Court and it was upheld that he has been disqualified. He has been punished for 2 years. Then immediately after his conviction, the parliament disqualified. Lok Sabha Secretariat issued a notification and they informed the election commission that Rahul Gandhi is disqualified. Now, the notification stated that he was disqualified in accordance with Section 8 of the Representation of People Act of the Constitution of India. And Section 8 of the Representation of People Act basically says that on conviction of certain offences, the person wherein 2 or more years, then it allows the disqualification of a member of parliament with any accordance with the law. So this is what it is trying to say here, that when the language is plain, the Representation of People Act very clearly lays down, and Article 102 of the Constitution lays down that any member of parliament who has been convicted for punished for more than 2 years, then 2 or more years, then they will be stand disqualified. And this is what happened in this case. However, later there was a stay which was granted by Supreme Court, and this matter, I think, is still continuing. So this is how you have to read the plain language clause. There is another case which you have to read is from, M.V. Joshi versus M.U. Shimpi and others. And this is talking about the fundamental principle of interpretation, that you have to see the language from its, if the language words are clear, you don't go into the details of understanding it. So in this case, and you will see in most of the interpretation cases which will come to you, we will be dealing with the classification of goods. Like I think you may be knowing about the classification of goods under GST, HSN codes are there, and there are the different in customs, there are the goods which are differently for taxation purposes. The goods are categorized into different one. Like for example, GST is more in a AC hotel than a normal hotel, right? So likewise, so here this the appellant M.V. Joshi was a butter dealer, and he was convicted for selling butter that was below the prescribed standards. Now here the core issue was that whether the butter prepared from curd, that is white butter, falls in the definition of butter, or it will only include the processed butter like Amul butter. So in this case, the food inspector seized the butter from M.V. Joshi's shop, which upon analysis was found to contain 18.32% fat, foreign fat, and this much of a moisture and this much of a milk. Now, thereby failing to meet the prescribed standard under Rule so and so of the Prevention of Food Adulteration Act. So the judicial magistrate initially acquitted Joshi, arguing that butter prepared from curd did not fit the legal definition of butter. However, the High Court overturned this acquittal and asserting that butter prepared from curd is indeed covered by the definition, and that selling butter below the prescribed standard qualifies as selling adulterated food. Now, so the Supreme Court upheld the High Court's decision, adjusting the sentence from rigorous imprisonment to fine, thereby reinforcing the interpretation that butter made from curd is subject to same standards as butter made from directly from the milk or cream. So this is how the interpretation exercise happens, and the plain language, if it is giving a clear meaning, then that meaning will be taken into consideration. So now I think I have explained you the basic principles of interpretation. Now we will move ahead with different rules of construction, right? Or rules of interpretation. So there are two basic rules of interpretation, as you can see, which is there in your book. One is called primary rule, and the other one is referred to as secondary rules. So in primary rules of construction, we have first rule is rule of literal construction. This I have explained you. Again, I will explain. Then second one is rule of reasonable construction. Third is rule of harmonious construction. Fourth is rule of Haydn's case or mischief rule. Fifth is rule of beneficial construction. Sixth is rule of exceptional construction. And then we have rule of ejusdem generis, doctrine of nocitur e socii, and doctrine of contemporanea expositor. So we will see each one of them one by one. I think someone has a question or clarification. Just a second. Yes. So this particular Daksh, I think your point is right that whether that should be closed or not. But in this situation, the probably in present days there may be a closure. But Food Adulteration Act provides for the penalties and all those. Now the penalties have become very harsher. This is an older case, right? Now let us look at the first one, rule of literal construction. So rule of literal construction, as the name suggests, is saying that whatever is written in the law, you interpret the law as per the written words. So the literal rule, also known as the plain meaning rule, is a type of statutory construction which dictates that statutes are to be interpreted using the ordinary meaning of the language of the statute, unless statute expressly defines some thing which is otherwise stated or some special meaning is accorded to it. So in other words, law has to be read word for word and should not divert from its true meaning, right? So it is the mechanism that underlines textualism. That means you just read the text, black letter law, and you don't go into the interpretation of the words unnecessarily. So the Latin maxim absoluta sententia expositer non indigit is the maxim which applies here, and its literal meaning in English would be an absolute sentence or preposition needs not an expositor. That means plain words require no explanation. So if law is clearly written, you go ahead with the rule of literal construction. This is what it says. Thus, it is primary duty of the court to interpret the words used in legislation according to their ordinary grammatical meaning in the absence of any ambiguity or doubt, right? So this is what is the objective of this rule of literal interpretation. So if you look at the books on jurisprudence, interpretation, you will find that the intention of the legislature is primarily to be gathered from the language used, which means that attention should be paid to what has been said, so also what has not been said. So you cannot import something. So it is not only about what has been said, you have to also see what has not been said. As a consequence, a construction which requires for its support addition or substitution of words, or which results in rejection of words as meaningless, has to be avoided. So you cannot just reject a word. If there is may, then you have to read may. If it is shall, it has to be read shall. If it is saying means, then you have to read means. If it is includes, then you have to read includes. So you have to, you cannot just take away one word and interpret it in your favor. That cannot be done. This is literal ruling. Another important point here is that the language should be read as it is. So you cannot substitute or add any word. As it happened in the case of British India General Insurance versus Captain Itbar Singh. So what was the question here? The scope of defense which was available under section 96(2) of the Motor Vehicles Act. So Motor Vehicles Act provides for the regulation of motor vehicles, and insurance is mandatory there, right? Third party insurance. So in this case, the court held that the insurers cannot challenge the quantum of compensation awarded unless they prove one of the grounds specified in 96(2) of the Motor Vehicles Act. No additional ground may be added by inserting the word also after the words on or any of the following grounds, right? So you can see here, this is the law, At the bottom, you can read the law. It is saying no sum shall be payable so and so. And toward the end, it is saying to defend the action on any of the following grounds. Now here the grounds are specified. If there are 5 grounds, you can have only those 5 grounds. You cannot have the sixth ground by using the word also. So the court reinforced the doctrine that no word should be added or omitted in interpreting statutory texts unless absolutely necessary to avoid absurdity or inconsistency. So this is the literal rule. That means you interpret as written in the text. Okay. Now there is one interesting case, which has which we deal with is called causus omissus. So causus omissus is a maxim, and it came up in the case of Gladstone versus Bower in 1960. The This was a decision foundational in contract law that explores the principle of equitable estoppel and that requirement for clarity in contractual terms. So it emphasized the importance of interpreting contractual terms based on the plain meaning without assuming additions or substitutions. So you cannot add anything into the contract. You have to read what it is. So the court held that no words or obligations can be implied into a contract unless it is necessary to give business efficacy to the agreement. So the principle applied was that parties must abide strictly by the words of the contract unless those words lead to absurdity. Now, this specific case basically underscores 2 points. The first one, that the literal rule of construction requires interpreting a statute or contract exactly as it is written. Second, the court should not modify contracts by inserting or omitting terms, except in circumstances where omission makes the contract unworkable. But I have seen that courts don't interfere with contract even if it is unworkable many a times. So you can see there was one case, very very infamous case, Rogers versus Alliant, and this case, there was a termination clause which was based on a comma. So this interpretation, actually billions of dollars were involved in this particular case, and I give this particular case as an homework for you people. We will discuss this on 15th again, and please explore what is this case about. I'll ask you this question, okay, in next class. Rogers versus Alliant. This case was lost because of a comma in the contract. So you can see how relevant it is and how important it is for looking at the cases, the interpreting the words in contract or maybe statute, very important. In another case, Bangalore Water Supply versus Sewerage Board, the case involved the interpretation of the term industry. And under the Industrial Disputes Act, so the court extended the statute's scope by interpreting the term industry expansively while acknowledging the omission. So at some places, the court also acknowledges the omission. So this is the principle of causus omissus, where courts sometimes provide the omission, but generally in normal circumstances, courts won't provide for omission and it will interpret the law as it is. But you remember the principle that the law has to be made workable. So in situations where there is a requirement of actually provide certain things, the court may try to make the law workable. Like in the case of Industrial Disputes Act, it is a welfare code, welfare legislation, right? So to benefit, the court has provided. But if it would have been a taxation legislation, probably no causus omissus would have been provided. So it depends on context, which kind of a legislation it is. The court may apply the interpretive principles accordingly. I hope this is making sense to you people. Yes? Rule of literal construction, is it clear to you or any question you have? Rule of literal construction and causus omissus. Any question till this point? Yeah. If you have question, please ask. Omission means left out or left. That is what is called omission. Bhul jana, chhoot jana. That is called omission. Like you are having a duty to do something and you don't do it. That is called omission. Okay. Now let us talk about avoiding rejection of words. So you are not supposed to reject also the words. You cannot reject the words. Every word in a statute is assumed to have been deliberately included by the legislature. So courts should strive to give meaning and effect to all words, avoiding interpretation that render any word phrase superfluous or redundant. Okay. So in one case of State of Bombay versus Ali Gulshan, the question was with reference to section 6, clause A of subsection 4, and there the one of the portions was unnecessary, and the state government may by order in writing requisition the premises for purposes of a state or any other public purpose, and may use or deal with the premises for any such purpose in such manner as may it appear to be expedient. So this is the case wherein this was Bombay Land Acquisition Act. So this matter related to acquisition of land. Okay. So the validity of act is not questioned as unconstitutional or beyond the scope of the legislative competence of the state, as the premises were required for housing a member of the staff of a consulate. There cannot be no doubt that it was wanted for public purpose. So the question here was that you have to see whether the act was meant for public purpose or not. So this is the case here. So in any event, other public purpose in a category distinct from union purpose or state purpose, an acquisition or requisition of property by the state except for the purpose of the union is within the competence under item 36 of the state list. So basically here the land was acquired or the property was acquired for consulate, that was considered as public purpose. There was no need for any other interpretation in that. That is how this particular case came about. So you should not unnecessarily reject a word for your convenience. This is what this particular provision is saying. Cross in statutory interpretation states that the governing idea in this situation is that statutory provision is intelligible in the context of ordinary language. It ought without more to be interpreted in accordance with the meaning of an ordinary speaker of the language would ascribe to it as its obvious meaning, unless there is sufficient reason for a different interpretation. So this is called, layman's language, or you can say a reasonable person. So in law, there is something which is called a reasonable person. So how a reasonable person will think, if he is thinking into that particular way, that is the interpretation standard. So you don't look for a genius for a general interpretation. You look for a common man. How a common man will look at that situation. This is what is the standard of interpretation. Thus, the ordinary meaning or grammatical meaning does not imply that the judge attributes a meaning to the word of a statutorily independent of their context or the purpose of a statute, but rather they adopt the meaning which is appropriate in relation to that. By enabling citizens and their advisors to rely on the ordinary meanings, unless notice is given to the contrary, the legislature contributes to the legal certainty and predictability for the citizens, and to greater transparency in its own decisions, both of which are important values of democratic society. So Lord Reed in House of Lords cases, in determining the meaning of any word or phrase in a statute, ask for the natural or ordinary meaning of that word or the phrase. They don't go for a detailed meaning of that particular word. So you have to see from a common standard, from a common ordinary standard, the meaning of the words. The rules of construction are our servants and not masters. This is what they say. And a statutory provision cannot be assigned a meaning which it cannot reasonably bear. If more than one meaning are capable, you can choose one, but beyond that, you must not go, right? So you cannot import any other meaning. If there are two meanings possible, you choose one that is possible. Then comes this is what is the rule of literal construction. So all the principles which we studied is about literal construction. So let us have a quick recap on literal construction. If you have to write say, for example, few lines, there's a note which comes 2 marks. Explain rule of literal construction. So rule of literal construction says that you read the text of the law as it is. You cannot supply for any word or take away any word from there. You apply the meaning from a common man standard, or you apply only the ordinary meaning of that particular words. This is what is rule of literal construction. You see it from the letter. So, okay. Law must be read word to word. Very good, Sushmita. That is what is the meaning of rule of literal construction. Now comes the rule of reasonable construction. Unfortunately, rule of literal construction many a times does not solve the purpose or solve the problem. And hence, many of the times you have to go for a rule of reasonable construction. So what is rule of reasonable construction? This is also referred to as golden rule of interpretation, because most of the times you will try to make the statute workable, right? So here in this situation, you look at the golden rule, and golden rule of interpretation basically is a legal principle that allows courts to modify the meaning of the law to avoid absurd outcomes. It is used when the literal meaning of the law is clear but leads to an unreasonable or unjust result. And the words of a statute must be construed ut res magis velet quam peret, meaning thereby that words of statute must be construed so as to lead to a sensible meaning, right? So when a grammatical interpretation leads to a manifest absurdity or illogical outcome, then courts shall interpret the statute so as to resolve that inconsistency and make the enactment a consistent whole. This principle is based on the rule that the words of a statute must be construed reasonably so as to give effect to the enactment rather than to reduce it to futility. Now, the principle is contained in Latin maxim, as we have already discussed. In short, statutes should be construed grammatically. Now, let us understand this by way of an example. And this example is coming from Alder versus George. This is 1964 Queen's Bench 7. So this is an English public law case, and it exemplifies the reason for a golden rule. So here what has happened is the law said that the section 3 of the Official Secrets Act was there. Okay. So the law said that it was an offense to obstruct Her Majesty's forces in the vicinity of a prohibited place, right? So it is using the word in the vicinity of a prohibited place. So if you look at on the right side, the diagram, A is the RAF station, that is dark blue, right? So as per the provision, in the vicinity will include all the light blue section, okay, near the A. Is it clear till this point to all of you? Yeah. Yes. So here the defendant, the person against whom the case was filed, entered the RAF station. So he was inside the RAF station, that is in the dark blue place. And he said that read the law literally, because law is saying in the vicinity, it is not saying in. So the key issue was whether the defendant, by entering the RAF station, violated the terms of the act, given the literal interpretation of the in the vicinity. Quite an interesting argument, right? So the lawyers make interesting arguments. So in the High Court, the defendant's conviction was upheld under the golden rule of statutory interpretation. The court applied the golden rule to avoid an absurd outcome and extended the meaning of in the vicinity to include in or in the vicinity of, right? So the Lord Parker CJ emphasized the potential absurdity in strictly adhering to literal rule. He stated that it would be extraordinarily and absurd if an indictable offense was created when obstruction occurred just outside the precincts of the station, but in the vicinity. On the other hand, no offense would be created if the obstruction occurred directly on the station itself. So the judges' use of the golden rule allowed for a more reasonable interpretation that aligned with the broader purpose of the statute. Quite an interesting example, right, from the Queen's Bench. Then there is something which is called rule of harmonious construction. So rule of harmonious construction comes into picture whenever there is a conflict between two statutes. So this rule is applied when there is a conflict between two provisions of a statute. So the rule comes into also support when there is a conflict between provision of a statute and the object for which the law has been made. So let us take an example. So environmental regulations versus economic development. This is most of the time, this is a conflict which will be coming up. So if one law protects the environment while other encourages economic development in the same area, the court can use harmonious construction to balance the two laws. And this has happened, if you will see, I think Bustard's case, Supreme Court dealt with, I think in Rajasthan, wherein solar panels were to be installed in deserts, and these birds called bustards used to fly and immigrate and come. So environmentalists file a case before the court, and they said that, see, it is going to affect the ecology. These particular birds will not fly because there will be solar panels installed. So the court looked at it and they brought the principle of sustainable development, and they said that both needs to be balanced. That is called rule of harmonious construction. Similarly, if you will see in case of economic matters, they also talk about rule of harmonious construction. So harmonious construction comes from the word harmony. Okay. One of you have asked the question, what is harmonious? Harmonious is basically harmony between two provisions or the object and the provision, right? This is called harmonious. So there is another case, that is Goa Foundation, Hanuman. These are all environmental law matters wherein the courts have made a harmonious construction. They have tried to make a balance between the economic development at the same time the environment. So it is a basic rule of interpretation that if it is possible to avoid a conflict between two provisions on a proper construction, then it is the duty of the court to construe them and they are in harmony with each other. So a specific rule will override a general rule. So this is also a very important principle. A specific rule will override a general rule. This we have seen in General Clauses Act also. So this principle is usually expressed by the maxim generalia specialibus non derogant, right? So a special rule will override a general rule. Always remember that. Aanchal, could you get harmonious construction? Could you get the harmonious construction? No. Okay. So harmonious construction, let me explain in a simple language. So say, for example, there are two laws, okay, and they are conflicting amongst each other. I can explain you this by way of constitution also. So there is a directive principle which talks about protection of, milch animals. So milch animals means the milk giving animals. And there is there are slaughterhouses. So they kill animals for food or something. So these are two things. Okay. So one says that protect animals. The other says that, okay, fine, you can have slaughterhouses. So now these two things needs to be balanced. You cannot have complete ban on non-slaughtering of animals. At the same time, you cannot have complete, allowing everybody to be slaughtered. So you need to have some balance. And that is where this is called harmonious construction. So if you see Constitution in one of the articles in directive principles, it says protection of animals. Then somebody may say that, no, it is my fundamental right to eat something, whatever I want. And like, for example, non-veg I want to eat. So you have to balance these two rights. This is called harmonious construction. Is it making sense to you now? Or I can give you an example, say this environment itself. You want to make buildings and there is a building rationale. So it says that, okay, fine, you can make the building, but only in the 75% area of your land. 25% you have to keep open. Why? You have to making a harmonious construction. You are trying to balance the ecology as well as the construction requirements. This is called harmonious. I hope it is clear to you. Let us move further and talk about another case. And this case is Commissioner of Income Tax versus Hindustan Bulk Carrier. So here the court laid down the doctrine of harmonious construction, and it said that while interpreting the provision, the courts need to avoid all circumstances of head-on clash between the provisions. They must be construed harmoniously. interpretation by the court should be done in such a way that one provision does not defeat the another provision, unless there seems to be no possible construction or no possible, what you can say, construction of these two. So if the situation is so that it becomes impossible to reconcile the provisions in conflict, the courts must decide in such a way that both provisions are given effect to. Any construction that renders one provision of the statute in dead, that should not be permitted. Harmonious construction is one which does not defeat any other provisions. For example, in Kerala Education Bill, the Supreme Court held that in deciding the fundamental rights, the court must consider the directive principles and adopt the principle of harmonious construction. So two possibilities are given effect as much as possible by striking a balance. This is what is the harmonious construction. I believe harmonious construction is clear. That is, Sridhar, this is quite an interesting one. If in Nagpur cheetahs are roaming in road and buildings, in this case, court protects the environment, that is cheetahs or public. Okay, here they have to catch hold of the cheetah and take them to the jungle. This is what has to be done, or maybe a zoo probably. They need to protect the people. But people should not take law in their hands and kill the cheetah. That is the point which should be there. Okay. Then there is an interpretation with reference to subject and object. So there has to be a harmonious construction with the subject and object to be achieved. Like for example, in UP Budhan Yagya case. So this law came up where Supreme Court said that the law came up to give land to the landless people. So you may be knowing that Zamindari system, there were many people who had no land. And this law came up that to take larger land from the Zamindars and give it to the poor people who didn't had land. So if you see the object and reason of this particular law, they clearly laid down that what is the idea for having these, laws, having these, laws of harmonious construction. So you have to see that there has to be a land ownership for poor people so that they can meet their economic needs. Similarly, this objects and reasons, in most of the law, you will find objects and reasons why this law has come up. Like, for example, this statement on object of reason for this one nation, one election bill is on the right side, you can see. So they are saying reforming the electoral laws. They have given the reason why this law should be there, right? So they have mentioned that there are multiple elections happening. There's a lot of cost involved in it. Electoral process takes so many times. So all these reasons are given, and that is the objects and reasons. And somebody may say that no, one nation, one election will take away the democracy. These arguments has to be harmonized. Okay. In some cases, the statute may give a clear indication as to which provision is subservient or which provision overrides, right? So in a law, many a times you will find that the law itself says that X provision is more powerful than Y provision. How do you come to know? By way of the usage of the terms subject to, notwithstanding, and without prejudice. These three terms you will find in many legislations, and you have to interpret it in a way. Like, for example, if there is something which is used subject to in a provision, then when the said subject matter is covered by the provision and by another provision or enactment subject to which it operates, then there is a conflict between them. The latter will prevail over the other. I will give you an example so that it becomes clear to you. Section 13(2) of the Companies Act says any change in the name of the company shall be subject to the provisions of subsection 2 and 3 of section 4 and shall not have effect except with the approval of the central government in writing. So what is subject to? It is saying subject to the trademark requirements. It is saying subject to the registration requirements. So you can change the name, but change of name has to be subject to the requirements which are mentioned in such section. I hope you have got the word subject to. Then there is something which is called without prejudice. So when certain particular provision following general provisions, and when it is stated that the particular provisions are without prejudice to those general provisions, the particular provisions would not restrict or circumscribe the operation and generality of the preceding general provisions. So if I say without prejudice to your marks, you can respond to my questions. What does it mean? I am exempting you from deduction of any marks. You can raise questions. So I'm saying without prejudice to deduction of any marks, you can raise questions. So your questions are not subject to the marks requirement. This is the term without prejudice. Then there is also something which is called non-obstante clause, or it is called notwithstanding clause. So a clause that begins with the words notwithstanding anything contained is called a non-obstante clause. So unlike the subject to clause, the notwithstanding clause has the effect of making the provision prevail over others. So when this term is used, then the clause will prevail over the other provisions mentioned. I will explain this in different levels. So if you will see under your course material, a notwithstanding clause has been talked about at 4 levels. So first one is the clause will override such other sections and subsections. So it is saying notwithstanding anything contained in another section or subsection of that statute. So here it is referring to Companies Act, and it is saying notwithstanding anything contained in subsection 9, subsection 10, any private placement issue so and so, so and so, so and so. So basically what it is saying, that irrespective of the fact that something has been mentioned in 9 and 10, you exclude it, right? So this is non-obstante, but this is the non-obstante of first level. Then there is non-obstante of second level, which says anything which is mentioned in the statute. This is not referring to a particular section. Second one is referring to the complete statute. In this case, the complete company law. So it is saying section 8.8, if you read, it says notwithstanding anything contrary contained in this act. So it is referring to the whole act. Third is talking about a situation where notwithstanding contained in any specific sections or all other provisions contained in another statute, where it is referring to other statute also. Like for example, section 7A of the Securities Contract Regulation Act. It is not only referring to Securities Contract Regulation Act, but it is also referring to Companies Act. So it is saying whatever has been said in Companies Act, you exclude that also. And this will prevail over that. The fourth one is talking about notwithstanding contained in any other law for the time being in force. So this is the highest level. So it is saying that the provision of this law prevails over all other provisions. This is what is the fourth level of notwithstanding or non-obstante clause, as you can see here. Like, for example, section 8 of the Securities Contract Act, it says the rules so made are amended shall, notwithstanding anything to the contrary contained in the Companies Act or any other law for the time being in force, have effect, right? So it is saying any other law. So you can see the first stage is talking about the same section, subsection. Second is talking about anything in that particular statute. Third is talking about a particular statute. And fourth is talking about any other statute, all statutes. Okay. I hope this non-obstante has given you a bit of an understanding. You can read more. It will give you better clarity. Okay. As I told you before, that these provisions are a bit ticklish and in core legal language, so you may face some difficulty in understanding them. But my advice would be that please utilize these 2-3 days to read them and bring up your questions in the next class so that all your doubts are clear. Now let me proceed further and talk about the rule in Hayden's case, or this is also referred to as mischief rule. It is quite an interesting one. Mischief rule. Have you heard about this word, mischief rule? What is a mischief, by the way? Have you heard about word mischief? Mischief. Okay. An act causing some uncomfortable happening, doing something wrongdoing. Okay. So you will see whenever law is made to solve a problem, isn't it? And that problem is referred to as mischief. So this particular rule basically says that whenever you have to interpret a law, you look at the situation before that law, you see the situation during the law, and whether it is curing that situation or not, right? Like, for example, if I have to see IBC, Insolvency Bankruptcy Code, from the lens of mischief rule, then what I will see? I will see what was the position before IBC, that creditors were not in control, debtors were in control. What was the purpose of the bringing the law? To give creditor the control of the proceeding if there is a default. So this is what was the mischief? Whether that mischief is getting cured in the new law or not, this is what is called rule in Hayden's case or mischief rule. So this case was, this rule was laid down in the Hayden's case. This is called mischief rule in 1584. So the case involved basically the lease, life estate and statutes. So Ottery College was one of the college which granted tenancy in a manner to Ware and father and Ware the son. So this tenancy established a copyhold, was subject to Lord's will and the manor's custom. The same parcel was later leased to Hayden for 80 years. Now Parliament enacted the Suppression of Religious Houses Act dissolving religious colleges. However, the act protected grants made over a year before its enactment. Now here the Court of Exchequer found that the grant to Wares protected but declared Hayden's lease void. Now here Lord Coke described the process through which the court must interpret the legislation, and it said that you have to ask 4 questions. First, what was the common law before making of the act? What was the mischief and defect for which the common law did not provide? And what remedy Parliament gave to resolve that particular situation? And true reason for the remedy. And the court said that you have to look at those reasons in interpreting the law and see that whether that problem is getting solved or not. If the problem is as it is, then there is no point, right? The problem gets to be solved. So this office of judges is always to make such construction as shall suppress the mischief and advance the remedy. That is the idea. And to suppress subtle inventions and evasions for continuation of mischief and pro privato commodo. Right. So this is what is the rule of mischief. Simply, if you have to understand, you have to see that all legislation comes up with some problem solution. Whether you have to see what was the problem, what was the situation before the problem, whether the law brought solving the problem or not. If it is not solving the problem, then the court will give an interpretation to solve the problem by way of a legislation. Let us look at another example. This example is about price competition. So see, in section 2D of the Price Competition Act, the section defines price competition as any competition in which prizes are offered for the solution of any puzzle based upon building up arrangement, combination or permutation of letters, etc. Like for example, Sukodu or maybe any other example. And if it is attached with prize, then that will be called as price competition. So here the issue was whether the act applies to competitions which involve substantial skill and are not in the nature of gambling. So here the Supreme Court said that here the idea for bringing up this particular law was to control the gambling and competitions where success rate is not dependent on substantial degree of skill. And that is how it was held in this case, that you have to have a history of legislation. You have to see the object with which it is made. So the Supreme Court in Kanailal, Paramanidhi has also looked at it, and it said that so frequently cited with approval of courts administering provision of welfare enactments that they have now attained the status of classic. So mischief rule is something which has been very regularly applied by the court. However, mischief rule cannot be applied if there is no ambiguity. If the language is plain, no mischief rule. So you have seen what is the first literal rule, then harmonious construction, then purposive construction, then harmonious construction, And now we are dealing with mischief rule. So these are these different stages of interpretation. You begin with literal interpretation. If everything is all right, you don't need any other interpretation. Then you go ahead with purposive interpretation. Then you go ahead with harmonious construction. Then you go ahead with mischief rule. However, this mischief rule, there is a critique. I will not touch upon this because this will become too, what I say, detailed for you people. But you can read this. I'm going to share this particular slide with you. So you can read this. And if you still have question on this, I will be more than happy to discuss that later. Then there is a rule of beneficial construction. So rule of beneficial construction is actually not a specific rule, but it is a method of interpretation. Okay. So as I told you, there are certain beneficial legislations or beneficial statutes. So a beneficial construction is given when that particular law is trying to protect or give benefit to a particular class of people, right? Like, for example, women, or you can say workmen or poor people. That is where the rule of beneficial construction comes. Like, for example, in alembic chemical workmen, the industrial tribunal awarded more number of paid leaves to worker than was mentioned in 79(1) of the Factories Act. Why? They applied the beneficial construction. They said that, okay, fine, these are the workers, poor workers, and that can be given some benefit. Similarly, in Tolaram versus State of Bombay, the court observed that it is a well-settled rule of construction that penal statutes that if two possible reasonable constructions are there, you give the benefit of doubt to whom? The criminal, the accused. So this is also a rule of beneficial construction in terms of the penalty. So you have seen Article 21 of the Constitution of India. Article 21 of the Constitution of India says, this is a single line article. It says, no person shall be deprived of his life or personal liberty except according to the procedure established by law. Now see, such a single line, but by way of a beneficial construction, the court has interpreted this particular law to provide for all sort of rights. You see how many rights? You can see 15 I have listed, and there are more than 15 rights which have been given by courts by interpreting this single line, right? Right to shelter, right to clean environment, right to privacy under the Puttaswamy judgment, right to live with dignity, right to travel abroad, right to sleep, right to internet, all these rights under Article 21. By way of what? By way of beneficial construction. Now let us look at another construction that is called rule of exceptional construction. So rule of exceptional construction comes from the maxim ut res magis velit quam perit, that it defines it is better for a thing to have effect than to perish. So it is basically saying that you don't fail the legislation. You try to make sense out of it, right? So the matter may have effect rather than to fail. So exceptional construction is a principle of statutory interpretation that is used to interpret statutes in a way that deviates from the usual rule of interpretation. So this principle is used when the usual rule of interpretation, such as plain meaning, rule of mischief rule, would lead to an unjust or unreasonable result. Let us look at an example. So in Maharaja Singh versus State of UP, an exception to the same word, same meaning principle was made regarding the interpretation of the word West as used in UP Zamindari Abolition Land Reforms Act. So when land and markets, haats and bazaar vested in the state, the word connoted absolute ownership. Whereas when vested was with Gram Sabha, the term implied a transfer of administrative control or possession for local governance and not full ownership. So you see, the term vested was differently interpreted in the case of state and Gram Sabha. So Gram Sabha, why it was done? Because Gram Sabha cannot sell the land to anybody. Otherwise, what used to happen is Gram Sabha would sell it, because Gram Sabha will have local villagers. They will all come together and they will sell the land. This has recently happened in our nearby village where I stay. The village, some people came together and they sold the Gram Sabha land, which was meant for all public. So this is how they are not given the full ownership. So I hope you understood this rule of exceptional construction. So that's it for now. I think I have talked about so many things today, and I can only say that you go through them these slides. I will be sharing it with you and read them thoroughly. Read the literature also, which is there with you, the course material, and come up with questions. If you have specific questions, it becomes more interesting for me to answer you, and that solves your purpose also. Because interpretation, as I told you in the beginning of the lecture, that it is a very vast subject. You cannot, you have to read many case laws and try to understand how this works. And some basic rules and principles I have tried to explain. Any questions you have, I will be happy to answer. Yes, Sridhar, Gram Sabha land is a government property, but you don't give power to the Gram Sabha to completely dispose it of, right? They can use it, but they cannot dispose it of. Is it making sense to you? Yeah, right. Okay. Yeah, I am located in Delhi. Any other question? This is a very confusing chapter, Isha. Yes, it is. And that calls for more reading. So my suggestion would be that please read more. So if you read and then clarify your doubts, it will be more easier for you. So my advice to you would be that 15th we are going to meet. Before 15th, please read the complete chapter, make your own notes about the different topics, and have questions in place. If you have not understood anything, I will be more than happy to explain you all these particular things. Okay? Yes. Yes, there are new words. Are there any questions from your side? If there are any questions, please ask it. ओके ईशा सप्रेस मीन्स टू दबाना जिसे कहते हैं उसे कहते हैं सप्रेस मिसचिफ मीन्स प्रॉब्लम अगर कुछ प्रॉब्लम है तो उसे उसको सॉल्व करना उसे कहते हैं मिसचिफ लूप होल जिसे कहेंगे ओके ओके एनी अदर क्वेश्चंस यू हैव एनी वन ऑफ यू okay in case you don't have any questions then we can call it a day okay so it is loophole to get away from punishment for mischief yes. No, it is not like that, Isha. Like when we say mischief basically, see, whenever a law comes up, what is the idea of law? Law is there to cure the mischief or the problem, right? Am I clear? Okay. Okay, then. Thank you, everyone. Yes, I'm just waiting for if there are any questions. If there is no questions, then we can wait. You people can exit if you don't have any questions. If you have any questions, I'm still there. No questions? Okay, good. Sushmita, please read the text and literature and do come with some questions in the next class. Okay. Because this subject is a bit bland, if you ask questions, then it becomes more interesting. Otherwise, then it becomes difficult for you to teach one way. Okay, then I think all of you can leave. Now we can stop the session. Thank you.